Intellectual property can be a very confusing area of study, mostly because the term property is generally associated with something fixed or something you can see. Simply put, it refers to any information good that is created by the mind, like an idea, design, certain names, or even writings. The concept of intellectual property is important to media because all of media is intellectual property. However, note that this idea and this notion is not exclusive to media alone. It also extends to the fields of music, literary work, medicine, art, and so much more. The creators of content exercise certain exclusive rights over his or her work. There are various kinds of intellectual property, but we are going to be looking at only two of them which have greater relevance to the media, that is copyrights and trademarks. Copyrights. Copyright is a legal concept that empowers creators to hold exclusive rights to content, generally for a limited period of time. Copyright in India is protected under the Copyrights Act 1956, which safeguards the right over content for a period of 60 years from creation or until the author dies. The creator of a work can prohibit or authorize the following: its reproduction in various forms, such as a printed publication or a sound recording, its public performance, as in a play or musical work, recording of it, for example in the form of compact disc or videotape, its broadcasting by radio, cable, or satellite, its translation into other languages, or its adaptations, such as a novel into a screenplay. Trademarks. A trademark is a recognized sign, design, or expression that identifies with the product. So, names, logos, taglines of media organizations fall under the trademark category and not under the copyright category. Trademarks are slightly more difficult to obtain as compared to copyrights. Trademark distinctiveness is an important condition to satisfy. Therefore, there can be only one times of window. Should a rival company come up with the same name, although they might have a different font style, maybe even a different tagline, it would be rejected because both companies are in the same category. So now that it is established that one of the many rights we have as creators of content is protecting it from infringement of various kinds, we need to understand exactly what this guarantee translates into the business of content making. For one, financial incentives. These exclusive rights allow owners of these intellectual properties to financially benefit from their creation. In 2013, the United States Patent and Trademark Office claimed that intellectual property contributed over $5 trillion to the US economy and also created employment for 18 million American people. The same article explained how Gleevec, a leukemia drug, costs $70,000 per year in USA, but only $2,500 here in India. The answer lies in the pricing of IP, in this case, the medicine. The same logic can be asked of media. Why was it that Memento was made at a budget of $9 million when its Indian adaptation was made for $7.7 million? The second reason is economic growth. The WIPO Intellectual Property Handbook states, one is to give statutory expression to the moral and economic rights of creators in their creation and the right of the public in accessing those creations. The second is to promote, as a deliberate act of the government policy, creativity and the dissemination and application of its results, and to encourage fair trading that would contribute to economic and social development. Of course, finally, it is also a matter of ethics to safeguard intellectual property rights.